Freedom-loving friends, Misty Carlfeld here with Health Freedom Idaho, and I'm here with attorney Colton Boyles and Sarah Clendenin, also Executive Director of Health Freedom Idaho, and we are here to talk about some of the attorney opinions as to whether or not the legislature can convene on June 23rd. Now, we have a few opinions before us. We have the AG opinion, and Speaker Scott Bedke hired an opinion, which I'm going to go ahead and just throw in there right now that it reflects who has hired the opinion. And then Idaho Freedom Foundation also hired an opinion that I think gives a better perspective, but I don't want to give too much away right at the beginning. So let's get started. So Sarah, who is our legal brain, our beautiful legal brain, did you know brains could come in such a gorgeous package?
Will you stop?
She hates it.
Stop it.
But I'm
I
gonna
hate it. Stop it.
So the AG opinion. So
Yes.
what should an AG, let's just also educate a little bit, what should an AG opinion look like? Like, does the AG represent the governor? Does the AG represent the people? What is the AG's role in this whole thing?
Well, let's not forget that the AG's office is also part of the executive branch.
Mm-hmm.
And it seems, especially given what we have in front of us, that the governor's office must think that that is their personal legal firm for them to write opinions, which the people are paying for.
Oh, it isn't?
No.
Because when I read it, that's what I got out of it.
No. It should be objective. It should study and reflect what's actually in Idaho code, what's actually in the Idaho Constitution, and what the courts have actually said in case law.
How interesting.
Isn't it, though? Yes.
And so what did you think about it, Colton, when you read the AG opinion?
I got the same impression. It seemed like it was a persuasive document, not an objective analysis. And it missing arguments that I think should have been made or at least mentioned that weren't mentioned. And I'd always understood the state attorney general, at least in Idaho, to represent the state in its sovereign capacity. And so it generally doesn't represent the state or the people. Looking at the statutes in the Constitution, the prosecutors have that parens patriae authority. So let's say the feds come in and botch, their forest management practices, and we get a massive bunch of smoke in the air, and it starts damaging our county's population. The local prosecutor would actually sue on behalf of the people in that situation, not the state attorney general. But the state attorney general does have an overlapping kind of concurrent authority to do that. But we had an old system that was changed where we used to have district attorneys, and now we no longer have those districts. We have prosecutors in each county. And so some of those delegations of duties to that prosecutorial arm of the state have been changed and shifted over time. And so I was disappointed reading it, frankly.
Agreed.
Mm-hmm.
Mm-hmm.
So what are the major holes that you see? I don't know who wants to go first here, but what are the holes that you see in this opinion? Because to be honest, a lot of legislators, especially senators, are using this opinion as why they can't go to the Capitol on June 23rd. And what's happening is that when our people call, and the citizens, our members and active citizens call their legislators, they're saying, no, we can't go, it's unconstitutional, right? And they're relying on this AG's opinion and frankly on Scott Bedke's attorney's opinion as to why they can't go.
Well, the first one I would note is the obvious disdain the executive branch and his attorneys, the attorney general, have for the legislature by issuing a proclamation that incorporates the ability of the legislature to meet and terminate his emergency. It says it right in the statute. So that analysis should totally get rid of this entire controversy right there. Number two, they're talking about these constitutional provisions, but if you look at Article 3, Section 15, it says no law shall be passed, right, except by bill, and there's more language there. But if you look at Governor Little's proclamation, it was his April 1st proclamation. There's an entire series of statutory language. The requirements of the following sections of Idaho Code are suspended. Wow, I didn't know he could suspend law as the governor. Well, I mean, there's an argument you can during martial law, but they vigorously argue we're not under martial law, right?
Mm-hmm.
So then there's more. For the duration of the May 19 primary, the statutory requirement in 34-1002-7 Idaho Code below reads, and they say, is suspended and amended to read. And so a governor who thinks he can draft legislation by proclamation obviously is going to have an attorney general opinion that says the legislature can't meet, which is absurd, because if they can terminate the emergency by concurrent resolution, it implies that they're passing a resolution which implies that there's a quorum. And the language they're relying on, to me, the sessions shall be held annually, right, unless there's another day appointed by law, and at other times convened by the governor. That's giving the governor to force the legislature to meet for a specific issue. It's giving the governor a little bit of authority to force the legislature to meet. It does not restrict in any way the legislature's authority to meet if they choose to do it, right? The legal profession is a self-policing profession. If I violate rules of professional conduct, the Supreme Court holds me accountable, right? If the legislatures get out of line on the floor, they're held accountable in the legislature, right? Mm-hmm. If one of the executive branch officials violates the law, well, then they're arrested and prosecuted like any of us, or they could be terminated or disciplined by the governor. So this whole idea of separation of powers has been totally lost, I think.
Absolutely.
It's like it doesn't exist.
Yeah.
Yeah. And there's no respect for it from our executive branch.
No.
They do not even acknowledge that the legislative branch has their own powers and duties not to be interfered with by the executive or the judicial branch.
Right.
And I would also say, I mean, they talk a lot about Article 3, Section 8, and I agree with you that that section of the Constitution does not preclude the legislature from convening. But on top of that, we seem to have this very adamant argument from the executive branch that there's no emergency, there's no attack, and so it leads us to the question, if that's the case, why are we under a state of emergency?
Yeah, it's very confusing.
And given the fact that we are under a state of emergency, I think that we would look to Article 3, Section 27 and the continuity of government, which is a call to the legislature that they have a duty to convene and to be the people's voice in the decision-making when we have an emergency.
Yes, absolutely. In fact, Representative Christy Zito said it best when she said the legislature is a surrogate of the people. And so we are clearly not being represented right now at all.
Absolutely not.
We have an authoritarian who's just doing whatever he wants to and is claiming that he can continue to do so without any representation of the people.
Right. And it's ridiculous because there's no reason. If we were under an attack where our state had been blown up or something crazy and the legislators were not able to come to the Capitol, there may be different legal arguments at that point, but we have absolutely no reason why our representatives cannot be at the Capitol, which of course is why we're calling them to come, to do the business of the people. The governor has no business suspending and amending sections of code and allocating money when our legislature, that is the duty of the legislative branch.
Right. Is there anything else that we need to address in this Attorney General's legal opinion?
There's a couple of really good points too on 67-422, right? It says that, you know, in the event of an attack, it doesn't say that the governor is the only one with the discretion to declare that it's an attack, right? It says in the event of an attack, the governor should call the legislature into session. And if he fails to issue the call, the legislature shall. So that says that the legislature has its own discretion to determine if there's an attack or a reasonable threat from an attack. You can't, they're arguing the governor has discretion, but the legislature doesn't. That's not what the statute says. Either one of them can declare an attack. They're policymakers, and so the judges aren't going to come in and say the legislature can't declare an attack because they don't have sufficient facts, just like they're not going to come in and say that about the governor. So that's a little bait and switch, like kind of a straw man argument there, and it leaves out basic statutory construction as well.
Well, and it really bothers me that they want to have it both ways.
Right.
They definitely constantly, especially in media, argue that we have all this justification. There's an imminent threat to the health of Idahoans and the lives of Idahoans. We're under an extreme state of emergency, emergency, attack, like all these words that get, invoke this emotional response. But then when we push back and say, oh, well, there's Idaho code to address that. Oh, no.
But it's not an emergency.
No. Now it's not an emergency and we can't look to those statutes for guidance. Forget it.
Just stay home, wear a mask,
do what you're told,
social distance, and don't question.
Exactly. Do not question, don't read law, do not read the Constitution.
Don't hold us accountable to those statutes. We just want to use them willy-nilly the way we want to, and we don't want to be held accountable for doing so.
And although
that's what we're being told
the responsibility of the legislative branch to be a check on the executive branch, we don't want to see that happen. That's not appropriate right now.
The executive branch doesn't want to see that happen, and the legislative branch really hasn't been brave enough to do it for the most part.
And apparently the attorney general thinks no set of circumstances exist requiring the setting aside of any constitutional requirement at this time. That's their analysis. There's no interruption of state or local government services. So it's like, on the one hand, they're saying, man, this is a huge emergency. We need to isolate and quarantine the entire state. But there's no circumstances that warrant any of this, this use of an extreme governmental power. So, I mean, you're talking out of both sides of your mouth, and you need to pick. You need to either own it and declare it, or open the state up, because this is embarrassing. And I mean,
so the speaker, Scott Bedke, he hired an attorney's opinion from Holland and Hart, and I couldn't decide as I was reading it. I was like chuckling and then infuriated, and then chuckling and then infuriated. Kind of went back and forth. So what is your takeaway as far as what the opinion that he paid for? Clearly, it seems like there was an end goal to this opinion. Like, here's what I want you to say. Now try to use statute to say it. It seems like that's how it was hired.
And it looks like that's how it was written. Well, first of all, it's 20 pages. So there's that.
It's more official if you have more pages. Just want to make sure we're all clear on that.
Yeah. And it seems to me to use very inflammatory language that in my opinion, is designed to scare off our representatives and senators. I mean, this one, Section 4, Idaho law bans a special session of the legislature on June 23rd. I've been studying this for weeks and weeks and weeks, and not in one place in Idaho Code or Constitution did I ever see anything that would make me think that a special session is banned. It's just very inflammatory, and I think that it's just designed to scare them from doing their job.
And this is the one I've actually heard the most, with senators saying we can't go. They're referring to this one the most. And I've seen emails where Senator Fred Martin has sent this to senators saying it's unconstitutional if you go to the Capitol on the 23rd and try to convene. So I think this one was really used, yes, to scare our senators into not going. And why would they logistically try to scare the senators in particular and not necessarily the representatives? Well, they know some representatives are going to go because there's some diehard representatives of the people in the House. And in the Senate, if they don't get one senator to go, then we don't have a quorum. And what happens if we don't have a quorum?
Well, the House can write the resolution to end the emergency declaration, but it is not a valid concurrent resolution without being confirmed by the Senate, passed by the Senate also.
Yes, so you can see why strategically it would be important, if you're the executive branch and you're enjoying your kingship, to not have the Senate show up on the 23rd.
And that's another thing that just occurred to me, is if the executive branch was so sure of all the points made here and all the points in the AG's opinion about the validity and the legality of all of these things, shouldn't they want our legislature there to challenge it? Shouldn't they want them to say, you know what, he does have this authority. We do have a legitimate emergency, and he does have this authority, and we're going to stand by him as the people's representatives and confirm what he's doing. But no, he's running scared. He's hiding. He's hiring all of these attorneys to write all these opinions, and then they're using fear and scare tactics with our senators to keep them away from the Capitol.
I knew how afraid the governor was of the legislature convening when I saw this opinion come out.
Absolutely.
And I was like, oh, this is his worst nightmare.
Yeah.
If he was really strong in what he was doing and he had the right to do it, you're right. He
Yeah.
would say, come on in, let's
Yeah.
have it out. Let's have the argument.
Let's have this debate on the floor.
He doesn't want to have the
No,
debate.
no.
He wants to stop the debate before it happens,
Yeah.
and they're using these fear tactics
Yeah.
to do so.
And he wants to keep us in a state of emergency
Mhm.
and continue to suspend and amend sections of code
Mhm.
illegally.
Yep.
And it's outrageous.
Yep. So any other takeaways from this particular one?
It's the Mark II on our basic federalism and separation of powers principles, where the states created a federal government. They delegated limited authorities and reserved to the states and the people the rest. And so state constitutions are a limiting document because the states are assumed to be able to do everything that's left, right? The federal is an express delegation of authority. So they totally missed the mark here. Consequently, in the absence of an express authorization, such power in the legislative department, to call itself into session, cannot be inferred from other provisions in the Constitution. But that's the wrong analysis. Unless there's an express prohibition on the legislature, you would assume they can. Now, if you're reading the federal Constitution, unless there's an express delegation of power, you assume they can't. So it's these little baits and switches all through the document. And if you read it and you haven't studied this like for months like Sarah does, you're going to miss these little intricacies where they sort of kind of trick you into going, ooh, yeah, that makes sense, you know? And they don't actually even cite Article 3, Section 8. They give it a partial cite. They say it authorizes the legislator to meet, and then they give you a little quote, and at other times when convened by the governor, right? Well, we talked about that. The session shall be held annually, right? It's forcing the legislature to meet once a year, and it's giving the governor a limited power to force the legislature to meet on a limited subject. It does not expressly limit the legislature from meeting more or changing the date or changing how many sessions. I mean, unless otherwise set by law, and we have 2 sessions, you know, once a year, they do that. If it says you shall meet annually, does that mean you can't meet twice a year? It just means you have to at least meet once. You could interpret it to limit that, but like they say in their document, this is one, but not the best interpretation of the sentence.
Just one final note on this Holland and Hart thing. They, throughout this entire document, use the terms essential and non-essential. And for any attorney to go there and use those words to describe a free people and their free market businesses is outrageous and insulting. So I just want to throw that out there.
Yeah, absolutely. So I spoke with Senator Regina Bear today because why should the separate but co-equal branch of government wait for the executive branch to invite them back to the Capitol if they're co-equal
Right.
and separate?
Right.
And she said, I know, and I'm not throwing her under the bus because I really like Senator Bear. She's really great, but she's also received these attorneys' opinions, and I think we need to have an answer to this argument. She said, that is an issue that we will have to take care of when we convene in January. That it's a flaw in our laws.
Why would we not handle it now? If we are truly in a state of emergency and the people's rights are under attack by our executive branch, that is the time that we most need our legislature to come back and be our voice.
Article 21, Section 15 says the legislature shall pass all laws necessary to carry into effect the provisions of this Constitution. And no one's put that in their analysis at all anywhere. So if there's a problem with how one branch of our government is treating citizens in a constitutional violation, if there's a problem with that, I think the legislature has every right to declare that an enemy attack and call itself into session.
Yeah,
Right.
and not only the right, but the duty to do
The
so.
duty.
It looks like Corey Langhofer and Thomas Bazile. I'm not sure if that's right. Bazile.
And as Sarah was reading through this, I was getting messages. Yes, yes, this is everything I've been saying.
Yes.
Yes, I said that too. Yes. And I was like, okay, because I just literally just sent it to her right when I got it. And I sent it to you. And I'm like, okay, so I'll get home and read it. But she was already devouring it and
Yes.
cheering. I could hear her from across town.
Well, it's just nice to see some common sense and someone actually objectively looking at what the code says and what our Constitution says. And so I was excited. Yeah. I mean, they start off with what I've been talking about all along, Article 3, Section 27 of the Idaho Constitution, as far as the legislature convening for the continuity of state and local government. I think that's a huge, important point. I was also thrilled, I hadn't even thought of or come across the fact that their first point of analysis is a special session pursuant to that section of the Idaho Constitution is a non-justiciable political question, as far as the judicial branch cannot touch that. That's not even something that the governor could challenge the legislature on in court. And Colton, you could talk about this more, I'm sure. But that the continuity of government operations is not a question to go before the judicial branch. That's just part of the separation of powers.
Yeah, I mean, if there's an element of discretion that is to be exercised by one of the branches of government, the court's not going to come in and replace that fact finding with its own. They're not going to say, well, the attack was only 8 out of 10 bad. It wasn't 9 out of 10 bad. It's required to be 9 out of 10 bad. So therefore it was an illegal meeting. The other thing is if the legislature meets and terminates the emergency order and then the governor sues them, I mean, it's going to be too late at that point. You know, you really think the judges are going to step in the middle of that and say the legislature thinks one thing, the governor thinks the other. Now we get to come decide and exercise that discretion? I don't think so.
Right.
And this is exactly why this is a political question.
Right.
And this is exactly why we have a separation of government, because we don't want a tyrant telling our people's representatives they can't terminate an emergency when the people want it terminated. Don't we get to decide if we want to risk a virus being on some surface and touching it and getting sick?
Yeah, that is not a function of government.
Yeah.
Yeah. And I think that that's a really good point you just made. What is the legislature afraid of? Even if we were wrong in all of these legal opinions and everything we're talking about, if they went in and terminated the state of emergency, you're right. The judge is not going to come in and say, you know what, I think you were wrong, legislature, so we're just going to go ahead and reinstate the state of emergency. That's not going to happen. There's not going to be a legal consequence on our legislature for exercising their duties and powers.
So I did hear that they were afraid of being sued.
I don't think so. I don't think that can happen. I think that Colton's right. I don't think the judge is going to step in the middle of that.
Well, you can sue anybody. I mean,
yeah.
But what's it going to do? You know, look, the governor just simply cannot write or amend or suspend laws. It specifically states rules, regulations, and orders. It's all about the executive agencies. He doesn't get to touch the legislature, right? None. He can call them into session and let them decide on an issue he wants them to decide something that's important, but he doesn't get to determine if the legislature interprets their constitutional authority to come together as a quorum. We're not talking about, you know, that Holland and Hart opinion where they were like, oh, just a few legislatures would get together in the continuity of government and they would make all the rules. Nobody's asking for that. We're asking for a quorum of both of the houses to come together and terminate the emergency order.
Yes,
that's right.
Right?
Yep,
absolutely.
And so if the legislature interprets it can do that, it can call itself into session because there's been an emergency declared.
Right.
Absolutely.
The emergency has been declared.
Yes, and exactly.
And the legislature has the authority to terminate it, so then they can go. So, to me, it just blows my mind. I'm like, why is this so complicated?
Right.
You know?
Well,
and the court's not going to go, no, you can't, right?
Right. And it even says, they like to talk about Article 3, Section 8 about, you know, whether or not they can come back. It says, or at other times as prescribed by law. And in law, it says they can terminate the state of emergency at any time. It does not say at any time.
Yeah, but not at any time. Only when the governor says you can, unless it's in a regular session.
Right.
But except these sessions are mentioned. There's session, there's sessions, there's extra session, there's extraordinary session, there's regular session, there's subsequent session. So I wonder how all those are going to be interpreted. Don't those all have a different meaning? The legislature chose to use all those different terms.
That's a good point.
Very good point.
Yeah. special session, extra session, yeah.
Mm-hmm.
So then point 2 on this one is that there is a reasonable basis for concluding that an emergency resulting from a disaster caused by enemy attack does exist. So in this firm's opinion, the attack statutes do apply. I mean, that's in direct contradiction to the other opinions, but I agree. And I mean, they lay out here case law and constitutional law, and I think they have a very strong argument on that point. And then again, just as Colton's already said, no provision of the Idaho Constitution prohibits the legislature from convening in a special session. And it's absolutely true.
Yeah.
It talks about the different reasons for a session and how they can happen. Nowhere does it say any specific scenario of the legislature coming back cannot happen.
Right.
So it is not precluded from coming together.
And yet there's all kinds of terminology indicating that they can.
Right.
So
yeah,
if we think about this logically, they have to have a way to have an extra session or a special session. Like there has to be a way to make that happen.
Yeah.
That exists there for a reason. So me, not being of legal minds like you two, I'm like, well, then obviously they should be able to do so.
Right.
And also knowing they're separate branches of government, they should be able to do so. Why would one rely on the other to call them back?
Right.
I mean, this seems like a no-brainer, and like it's been very convoluted and messed up for a reason, and that reason is to keep the people from having a voice. Now we have to address this because this is the new talking point, you know, after the whole it's unconstitutional if you go, and so now the senators aren't going. Here's the new talking point, which is also despicable. This is from Senator Jim Patrick to one of his constituents when she asked for him to go represent her at the Capitol. He said, "Sorry, but I will follow the Constitution. We are not at war, and this attempt to overthrow our state government insults me."
Unbelievable.
So this is the new talking point. They are going to call this, you know, wanting to get back to the Capitol and terminate the state of emergency, an overthrow of our government.
That is so backwards. I just don't even know where to begin. First of all, it's the governor who has overthrown our representative form of government.
Exactly.
And respect for our 3 branches of government. They're supposed to be the check on each other. So he has illegally done that. We're trying to right that ship, and now somehow we are the ones overthrowing. So that's completely backwards.
You know, that whole reflection thing that they do.
Projection.
You know, the projection all the time. They're always projecting. They're always reflecting what they're actually doing onto someone else.
Right.
So
and that's exactly what he's doing.
That's exactly what he's doing. Parents out there, that under the state of emergency, the governor has suspended some parental rights. And so you want to talk about overthrown. They use the nice word suspended, but I feel my parental rights have been overthrown.
Right.
So some of those rights are, if CPS takes your child, getting to know where they go. Or the other one is getting to communicate with your child. And then their answer to that was like, oh, well, we're just moving it to Zoom. No, that's a negative. I need to be able to see, touch, feel, smooch my child. I need to know exactly where my child is. Your parental rights haven't been terminated when CPS takes your child, and they're acting like they have the authority to totally move your child somewhere where you don't know where they are, and suspend your right to see them and communicate with them. And that is just outrageous. And these suspension of rules are going to continue because he's going to keep lining out whatever he wants to line out unless we terminate the state of emergency. Do you see? Do you feel how urgent this is? It's not like we're just sitting here talking about some kind of, you know, tinfoil hat, something that could be happening. This is happening right now. Right now, we're living in a time of a suspended parental rights. Right now. Not tomorrow, not maybe, or it could happen. Right now, we're living under that tyranny.
Yes.
And the only way to stop that right now is to terminate the state of emergency. We have to terminate the state of emergency in order to keep the rights we have. They're already taking our natural rights all the time. And now we have some of these outlined rights, and he's stricken them. He's suspended them.
Right.
Out there, or there's a group of people out there who are able to do this, and we are talking to you. Yeah.
One final thing I just wanted to say, you know, I know we can talk for hours down in the weeds about the different sections of code, the different articles and sections of the Constitution, but it was impressed upon me today, and I was reminded, and I'm really thankful, that all of this is underneath the fact that we have certain unalienable rights. We have God-given rights. And we have a constitution written by our founders that guarantees us a representative Republican form of government. Right now, we do not have that. And that one point by itself is reason for our governor to call back our legislature.
Yeah.
And I just want to thank
that
the
was,
person who reminded me
a
of that.
That was a good reminder. On a
Yeah,
meeting we were on
it really
today.
is, because that is up above all of this.
Yeah. Yeah. Yep, exactly. Well, I think that wraps us up very well. Thank you, Colton, for taking the time with us. Do you want to tell everybody about your law firm so they know how to get in touch with you should they need to?
Yeah, thanks for the plug, Misty. It's Boyles Law PLLC. I go out of North Idaho. I'm licensed in Washington, Idaho, New Mexico, in the Federal Court of Claims. You can check out my website, cboyleslaw.com. It'll probably be down there. Feel free to call me, email me. We'll endeavor to be available at any time, because I know some of these matters are really time sensitive. So if you're a nurse out there and they're forcing you to get tested, or you have issues with your kid and CPS, or you need some business structuring or some real estate litigation, or you just need someone that can solve some problems with discretion and help you formulate a plan, then I'm happy to do that. And we've had a lot of success, and I appreciate it. And God's blessed us a lot. And so thanks for the plug, Misty.
Absolutely. I'm happy to do so, because you're doing great things, you know, and I've seen the result of the great things that you've done. So I really appreciate you very much.